Senator Batters, followed by Senator Boniface.
Thanks very much. Thank you very much, both of you, for being here. Ms. Lee, you provided some important information to us about possible charter non-compliance, and I note that in looking at your brief, on page 1 of your brief, you said, quote, amendments this severe and charter non-compliant will only harm our justice system. The proposed measures will lead to greater court delays and enormous litigation expense that will clog up the court system for several years. The ultimate effect will likely be that most, if not all, of the proposed amendments are struck down. And regarding mandatory alcohol screening, which we heard a lot of evidence about yesterday as well, you said, quote, why should suspected alcohol-impaired drivers be given fewer rights than suspected drug-impaired drivers? This suggests the law will not only be found to be, or will also not be found to be conducted in a reasonable manner when it is ultimately subject to a constitutional challenge, quote. And I note, just referencing Senator Pratt's point earlier, that the issue is not that charter challenges are going to take place. Of course, that's the case on probably almost every law that Parliament passes, but the issue is that there seems to be here potentially a high likelihood of being successfully charter challenged with these different provisions. But what I wanted to ask you about, Ms. Lee, at the House of Commons Justice Committee, you reacted to Professor Hogg's argument, saying that Bill C-46, in his view, was charter compliant under sections 8 and 9, and you said, quote, I don't see how Hogg can come to a conclusion that it doesn't offend section 8 and it doesn't offend section 9 when our Supreme Court of Canada has already ruled that the measures now in place offend section 8 of the Charter, that the measures now in place offend section 10B of the Charter. The proposed bill is stripping away more protections, quote. So I'm just wondering if you could please address that, the point about Professor Hogg's argument in a little bit more detail. Thank
yes,
you.
I'm still reacting to Professor Hogg's opinion. No, I think in the constitutional cases that have come before the Supreme Court of Canada thus far, like Thompson, Burnshaw, and Urbanski and Elias, the most recent one, each time approved screening device testing has been challenged, or roadside testing like SFSTs have been challenged, the court has said these violate Section 8 and 10B of the Charter. They're saved by Section 1 because of 3 components. Those 3 components are the reasonable suspicion requirement, the forthwith requirement, and the use immunity. In British Columbia in particular, we've eliminated use immunity because we have the immediate roadside prohibition scheme. So that's out the window already. And now we're taking away the reasonable suspicion and the forthwith requirements and making it simply just make people blow or make people, participate in these invasive testing procedures. And given that that's the state of the law already, and there's nothing to suggest that that's not good law, and in fact the Supreme Court of Canada followed themselves in Urbanski and Elias in the early aughts, I am of the view that Professor Hogg's opinion, while he's obviously a very well-respected constitutional scholar and has far more experience than me in the area, doesn't take into account the fact that the Supreme Court of Canada has not at any point shied away from what they said back in the 80s.
Mm-hmm. Thank you. And Ms. Lehman, at the House of Commons Justice Committee, you said about the limitation on disclosure, quote, the rationale for doing so appears to be in line with attempts to combat the perception of delay in the criminal justice system. The irony here is that this is more likely to contribute to delay. Defense counsel like me will be required to make time-consuming applications in order to access these documents, quote. So being that our committee has a very keen interest in the issue of criminal court delay crisis that we have going on in Canada right now, and we've seen that impaired driving charges currently, we have a massive number of impaired driving charges that take a very long time to go to trial, and as a result it's become a real glut on the criminal justice system in dealing with criminal charges, and so I wanted you to just address that issue of delay in a little bit more detail than you've had the time to do already today. Thank you.
Certainly. Thank you for your question, Senator Batters. Delay is a significant issue, as my colleague pointed out earlier, particularly with the legal landscape as it is now with the Jordan decision. So we have 18 months as the outer limit at this point for an impaired driving trial or any criminal offense to conclude. And we know that impaired driving cases take quite a significant amount of time already. So the average, I think, is between about 105 to 230 odd days to process through the court system. limitations on disclosure are only going to contribute to that, in my view, and the reason for it is that defense counsel are going to be making applications, and this bill does contemplate a mechanism to do that. It has to be brought both in writing and orally at least 30 days before trial, and we have to speak to those. So we will have to speak to those in court. We will be taking valuable court time. We know that our criminal justice system is already overburdened, so allotting more time to make these, in my view, unnecessary applications when we could do something else, like say publish these kinds of documents online, is short-sighted. These are important. You know, Section 11D charter rights cannot be easily discounted. People do have the right to know the entirety of the case against them. And that's for impaired drivers just as much as it is for anybody else who's been charged with a criminal offense. So the right to those documents is important. And I think it was Greg Yost that pointed out to this very committee that defense lawyers are creative and they will come up with ways to get their hands on those documents that they feel that they require in order to properly defend their clients. So making these kinds of applications is going to be time consuming, but also I have concerns about how quick defense counsel will have these documents and how readily they'll be made available. So if, you know, Crown isn't anticipating that they're going to have to disclose these kinds of historical maintenance records and so on and so forth, they will be left in a position, if an application is successful, to wait for police attachments to gather that information, to forward it to them, to redact it, and then to send it to defense counsel, which can also take a great deal of time, and it could create further delays if we have to seek an adjournment in order to review that material prior to trial. So I do think that there's going to be significant concerns when it comes to delay with the way that the disclosure provisions are set up in this bill, and I have concerns about that.
Thank you.
Thank you.